What's up, LinkedIn? This is Hillary, and I'm here again with Andy Mendelson, Chief Risk Management Officer for Berkeley Design Professionals, as well as an architect. Today, we're going to be talking about the indemnification clause in design professional contracts. The indemnification clause is a common contractual risk shifting mechanism, and I think this is one of the first clauses that was always tweaked and always discussed the most in design professional contracts. It's definitely evolved over the years, and it's certainly not the only contract clause that needs to be reviewed and scrutinized a little bit. But we're going to talk about this clause and what design professionals should look for when reviewing contracts. So, Andy, do you want to go ahead and talk a little bit about the indemnification clause?
Sure. And as you noted, the indemnity is a common contractual risk shifting mechanism. Indemnity language actually did not exist in AIA standard form agreements until 2007. You're better off as a design professional without an indemnity obligation. But when I was serving on documents committee at that time, we felt that because we are seeing so many uninsurable and unfair indemnity clauses coming back at us from owners, that we thought it would be a good idea to be proactive and provide a fair and insurable indemnity clause in what was then the B103 2007 and came forward in other forms of agreement since 2007. So what does indemnification mean? It means you're assuming a specific liability in the event of a loss. A design professional is legally liable for the damages caused as a direct consequence of its negligent act or omissions, which is exactly what is covered by your professional liability insurance policy. But it needs to be fair and insurable, and your client is really the only one who can benefit from the indemnity. When they start adding related parties and agents and contractors, you can't do that. So you're doing it directly for the benefit of the property owner, assuming that's your client, and its defined representatives only. It has to be based on negligent practice. And this gets back to the subject we talked about last week regarding the standard of care. It's negligent-based services, not perfection, and to the proportionate extent caused by the negligent performance of services. It has to be based on claims that arise from third parties, and it also needs to not include the word defend. So because providing a defense prior to a finding of fault is not insurable under PL policies. It's also important to note that indemnity laws vary from state to state. That's why when we provide contract review services, we always recommend that you check with your attorney who's familiar with the laws of the jurisdiction of the project. As an example, there have been a number of states that have enacted anti-indemnity clauses. And this has been due to the great work of the ACEC state chapters and the AIA and design firms and their attorneys who have advocated for fair and balanced indemnity obligations as a matter of public policy. So there are a good number of states that have these laws in place, but they can vary from state to state. So be careful that it is drafted in accordance with those laws. It is possible, though, while we're not going to provide an upfront defense, you can include the obligation to reimburse your client's attorney's fees and expenses if it is determined at the conclusion of the dispute resolution process that those are, in fact, the design professional's responsibilities. So it's a highly nuanced clause. We have standard language for it in the Berkeley DP Contract Review Guide that we have reviewed in previous conversations with you. And we recommend starting with that model language and then confirming with your attorney that it's enforceable and appropriate for the jurisdiction of the project.
At what point, because sometimes these indemnification clauses can be so one-sided, at what point do you suggest a design professional maybe walk away? I mean, this is, You know,
Yeah.
a lot of the times they understand they're undertaking some risks that really just aren't insurable, and this is their business, and they can't always walk away from every contract that isn't in their favor. But at the same time, at what point do the risks outweigh, you know, the benefits of getting the business?
That's a determination that we as an insurance carrier cannot provide to
Mm-hmm.
clients. That becomes a business decision. It really starts with the go, no go process when you're evaluating the project and the client. What do you
Mm-hmm.
know about the client's litigation history? You know, have they filed suits previously against architects or engineers or contractors? Are they a litigious client? Are they fair in dealing with contracts? One of the excellent phrases that one of our outside counsel provides to us is, if you put the phrase at the beginning, to the extent coverage is provided to the design consultant through its insurance policies required of this agreement, comma, and then just whatever the owner wants to say, that's going to pull the professional liability indemnity obligation within the context of the professional liability insurance policy. Now, when you've got a client, a project owner that does not care if you're insured for these risks, well, to me, when I was in practice as an architect, that became a key issue relative to the go, no go process. So yes, there's reward, the plus side of the project from your perspective. There may be clauses in the contract, including an uninsurable and unfair indemnity, that cause you to make a no-go decision and walk away from the project. So it's really a balancing act. No contract is perfect. We are providing advice to our clients that you need to balance the risk and reward of the projects and make an informed business decision as to moving forward.
And you have at Berkeley, you have a nice go, no go project tool spreadsheet that clients can certainly use. So that's a good point. That's a good way to kind of review and take a look at it. Switching gears, still on the indemnification clause, but so much that relates to the professional liability policy. What about on the general liability policy? Any thoughts or comments on that as with contracts and getting some coverage there?
Well, I'll start with a comment that I'm not a general liability expert, but
Sure.
my understanding is that the general liability policies are more liberal in terms of their approach to providing an upfront defense of a claim. This is why in contract, we always want the architects, engineers, other design consultants, and the owners identified as an additional insured on the contractor's commercial general liability policy, the CGL policy. Because if there's an example, a worker injury or a property damage that's caused by the contractor, you can tender that claim to the contractor's CGL carrier, and in most cases, they will step in and actually provide the defense. So this is where your expertise as an insurance broker, Hillary, is greater than mine relative to the general liability. But our understanding is that there is more broad coverage under CGL. That's why that phrase at the beginning, you know, to the extent coverage is provided, can be very, very helpful. And it can maybe ease the mind of the owner as well to know that, well, I know there's some of the insurance policies that'll step in and provide that defense. The owners just need to understand that the upfront defense obligation will not be provided by the professional liability carrier.
Can you very quickly touch on the three different types of indemnification clauses and the broad, the intermediate, and the narrow form, and which do you try to strive to have your clients have in their contracts? Or is there an appropriate time to have each one of those?
We use the terms mutual indemnity and one-way indemnity and bifurcated indemnity. Bifurcated meaning that we have a special clause for the professional liability indemnity. We have a different clause for the general liability indemnity, which we just discussed. The one-way indemnity is what we normally see requested by the owner, where they're looking for the architect or engineer to indemnify them. The mutual indemnity provides both parties indemnifying the other under the same kind of terms and conditions. So our mutual indemnity and our one-way indemnity are rather broad. Sometimes we see clauses proposed by owners that want broader indemnity for like a copyright violation. So you need to be careful about that, because professional liability insurance covers indemnity in the same manner, no matter what the nature of the claim is, by a third party. So it's really, we like to see it be more simple. And so our one-way indemnity is a simple paragraph with 2 sentences in it. And it just makes it cleaner. And that way the client has a clear understanding of the type of coverage you have relative to this sometimes onerous obligation for indemnity.
I have one last question before we want to end with any comments that you want to add about this clause. But sometimes a design professional can have, the perfect contract, or, they've all the right amount of liability within their contract, and they've had it reviewed by their attorney, they've had it reviewed by, their insurance carrier, and they're still brought into a claim. They've done everything right. They're still brought into a claim, because we all know the design professional usually has the deep pockets within the insurance, limits. So, and claims can get expensive rather quickly. So do you have any comments for design professionals on that? Because I know that happens, and quite often, and that's certainly a concern and a worry for my clients. So what do you have? What do you suggest? Or do you have any comments on that scenario?
The first comment I have is understand the contract that you have signed. Don't just stick it in the file and not be known as to the key aspects of it by your project team. So our recommendation is the project principal and the project manager, who should be intimately familiar with the contract, share the key aspects of it with their project team. And the goal here is to perform your services consistent with those contractual obligations that you have. In other words, if you have an agreement to review shop drawings within 10 business days, make sure you review those shop drawings in 10 business days. If you have normal responsibilities during a site visitation, make sure you perform your services in accordance with that site visitation, and don't start stepping over the lines into means and methods of construction or site safety or that sort of thing. If you're obligated to provide 3 options for schematic design, provide those 3 options in schematic design. Hopefully you've gotten fees to do that, but don't provide 2 and go on with the project without any documentation that your client was satisfied with those 2 options. So number 1, perform your services in accordance with the contract. Number 2, document consistently and contemporaneously as you're providing your services to demonstrate that you have performed in accordance with the contract. Now, that does not mean that even with excellent project delivery such as that and a very good contract, you won't get dragged in. You will, but believe me, when our claims officers work with you to help defend that claim, the contractual clauses are critically important, as is the project record that you've established. Communication and documentation, managing your client's expectations, and having a solid project record in your files that you can refer to due to decisions that were reached, options that were considered, and the like, is going to provide an excellent basis for the defense of a claim against you.
Great, thank you. Anything else you wanted to touch on as far as the indemnification clause goes?
I think we've been pretty thorough about it. So, again, the Berkeley Design Professional Contract Review Guide has an excellent explanation of the factors and of the sample clauses. I know other insurance carriers do the same. We think we do ours a little bit better. So please avail yourselves of those resources which Hillary can provide to you, and just be very diligent in contract review. Really, every word, every sentence matters, and there are reasons why the industry standard agreements such as AIAs, such as EJCDCs are written in the way they are. And just be very diligent in the review, be a strong negotiator, and have a successful project.
I'm going to put in a plug then for specialty agents like myself too. That's why it's important to have somebody that's, taking a big role with that niche with architects and engineers so they understand what to look for and can provide you the resources and help do the review and get you in touch with top tier carriers like Berkeley so that you can try and avoid, risks that are unnecessary. So, all right, thank you so much, Andy, and stay tuned for next time. It's time to bear down. Bye, everybody.